empowered domains. So, second, a state has no power to declare a holding of the U.S. Supreme Court unconstitutional as the preamble suggests that it might. As I think the bill implicitly recognizes, states do have certain police powers reserved to them under the 10th Amendment to legislate locally regarding the health and welfare of its citizens. That generalized police power does not include the power to contest through contrary legislation the constitutional decisions rendered by the Supreme Court. As to the operative sections of the bill, which purport to make it a crime for federal officials or state officials, a felony and a misdemeanor respectively, to attempt to enforce the provisions of the Affordable Care Act within the state, these operative provisions are unconstitutional in light of the theory as I've already outlined it. As I understand this concept of nullification, it is by definition a violation of the Supremacy Clause and occurs when a state legislative body attempts to prevent federal officials from implementing federal law, or state legislation purports to render ineffective, inoperable, criminal, or in any other way null federal laws within the state. H3101 purports to make it a felony for federal officials to carry out federal law, and as a consequence, the state of South Carolina cannot legally do this. It's not within its power. To do so would undo the very Constitution we support and uphold and pledge our allegiance to. Again, let me quote from Chief Justice John Marshall from an 1809 case. And if you notice, I'm referring to a lot of Chief Justice John Marshall cases from the early 19th century, suggesting how long and how deeply entrenched the tradition and the law on these matters is. It's not a recent matter. It's not something that's arisen in the last 20 or 30 years. It's something that goes back to these principles go back to the very founding of our country. So in the 1809 case, United States v. Peters, Chief Justice Marshall writes, if the legislatures of the several states may, at will, annul the judgments of the courts of the United States and destroy the rights acquired under those judgments, the Constitution itself becomes a solemn mockery, and the nation is deprived of the means of enforcing its laws by the instrumentality of its own tribunals. So fatal a result must be deprecated by all, and the people of, and let me add, South Carolina, the case was about Pennsylvania, but the people of South Carolina, not less than the citizens of every other state, must feel a deep interest in resisting principles so destructive of the Union and averting consequences so fatal to themselves. This isn't a debatable point. There is a definite and right answer here. The state of South Carolina has no power to nullify the Affordable Care Act. Let me end with one more consideration. Article 6, which also contains the Supremacy Clause, also requires, has what we call the Oath Clause. It requires that, quote, the members of the several state legislatures and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. This Constitution includes the provisions that federal law is supreme over state law. Thus, the members of the legislature of the state of South Carolina have taken this oath of office, and this oath of office binds them in their duty to uphold the Supremacy Clause of the federal Constitution, which says that duly enacted federal law is supreme within this nation. So with that, that's my prepared remarks, and I'm happy to answer questions.
Professor Crocker, the case Cooper versus Aaron, can you tell us about what was the issue? What were they talking about?
Federal court had ordered the state of Arkansas to desegregate. Governor Valdes had attempted to defy that order and to not allow African-American students to go to school with white students. And in response to that, the case was heard by the Supreme Court, who made it unmistakably clear. The Supreme Court doesn't have its own police force. It has capital protection, but it has no police force. It can't enforce it. The most they can do is essentially jump up and down and say, each one of us signs this individually. This is how law works in our system. And the governor did more pressure on taxpayers.
Have there been
I wanna
other
see his
exceptions
national
in the
ID.
country and nullification on other laws?
I wanted to see it. Show it to me.
Other places where the legislature
Good point.
basically nullified federal law and then called on that?
In the early 1830s, the state of South Carolina was involved in what is known as the nullification crisis, where the state of South Carolina attempted to nullify a federal tariff bill. President Andrew Jackson spoke very passionately and has a very good presentation of why this is unconstitutional. But over negotiations between the administration of President Jackson and the state government in South Carolina, a compromise was reached and no further sort of controversy was averted in the short term. So we didn't reach a constitutional case out of that. But other than that, I don't know of any other occasion where nullification has been contested, other than those that I have mentioned, Colby, Maryland, and earlier with the state of Maryland, where attempted to tax a federal bank unconstitutionally. I don't know of another nullification.
Any other members? Everybody does. Chairman Lane.
Professor Crocker, in your study of the history of nullification, have you ever seen a bill or a resolution or proposal that proposed to arrest federal officials, agents, judges, place them in jail for a felony, or arrest state officials and place them in jail for immunity for enforcement of a lawfully passed federal law, passed by both houses of Congress, signed by the President, and found at least in main part constitutional by 1963 court?
Yes, sir. This is unprecedented.
Representative Tyson.
President, I'm going to ask it a little different way, because I'm following the 10th Amendment website, and there's a lot of proposals I see from a lot of different places. And I'll read behind them, oftentimes it'll say, for example, Montana is going to arrest federal officials for doing blank, or weapons, Second Amendment issues or something. And I know Representative Delaney asked if you ever seen, there are proposals, clearly there are numerous similar proposals out there that indicate that they would charge the feds for enforcing federal law. That much is clear, is that correct?
I understand this is a contemporary issue.
Okay,
Lots of.
and so my question, it kind of piggybacks on what he said. Do you know of any indication in history, and I'm an old prosecutor, so that's what I'm trying to, when I first saw it, my concern is we're going to arrest the federal agents for doing their job. Have you seen any indication that anybody, a federal agent, for example, of course we cover state agents here too, has ever been arrested for enforcing duly enacted federal law?
Not that I'm aware of. That doesn't mean that it hasn't been attempted, but not that I'm aware of. But even if it had been attempted, it's clearly illegal. That's going to always be the baseline. The state agent doesn't have the authority unless the federal agent has committed a state crime, so possession of drugs or some other duly criminal act that the state has authority to criminalize.
But certainly not for doing their job.
For doing their job.
The second question I would have, and I've talked to many friends about this, the distinction of, for example, California, Colorado, wherever, and use of marijuana laws, for example. It's my understanding that in that circumstance, the states have basically said, we're not going to enforce marijuana laws anymore. But they have not said we will arrest, for example, if the DEA came and did enforce marijuana, they're not arresting the DEA for enforcing those laws. Is that accurate?
That is accurate. And if you'd like me to elaborate, that's a very good example because this is one of the confusing, sometimes it can confuse people. And so the state of Colorado, once upon a time, made it illegal to possess marijuana. It's illegal under federal law to possess marijuana. In such cases, states and federal government have concurrent jurisdiction. You can both make something illegal. But if Colorado decides not to make it illegal anymore, what that means is that state officers and state officials are no longer going to seek prosecutions in state courts, but the federal government is free to seek federal prosecutions. So the individual who possesses it is still breaking a federal law, even if they're not breaking a Colorado law. And an individual arrested under a federal crime by a federal agent has no defense that this is legal under state law. and the state would have no